I'm attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the third segment in a multi-part securities lawcast discussing reverse merger transactions. In the first segments, I explained what a reverse merger transaction is and broadly described the confidentiality agreement, letter of intent, and definitive merger agreement. Today, I am talking about the cost of the transaction, including the cost to acquire a controlling interest in a public vehicle. In a reverse merger transaction, the shareholders of a private operating business obtain a majority controlling interest in a public company and must pay for that controlling interest. That payment may be either in cash or equity, or both. In addition to the cost of acquiring the controlling interest, the private entity must complete an audit and pay attorney's fees associated with the transaction and the closing 8K or Super 8K. I generally suggest clients budget $100,000 for costs and expenses above and beyond the cost of the public vehicle, though many transactions may be completed for less. And although attorney fee time is generally the same for transactions big and small, the audit and accounting fees vary greatly depending on the maturity and complexity of the underlying private business going public. As for the cash price of a public entity, it can vary greatly. However, today and currently, the average price for a fully reporting public entity with no liabilities and which is otherwise clean is between $350,000 and $475,000. The cash is paid to the public company control shareholders in exchange for giving up and relinquishing their control ownership. The price variance depends on many factors. Factors include whether the public entity is a shell company or has existing business operations, the necessity of completing changes to the capital structure, such as through a reverse or forward stock split, the existence of liabilities, negative history of the public company, such as prior regulatory actions against the company or its former officers, directors, or control shareholders, the ultimate percent ownership that will be owned by the private operating company shareholders upon closing, how quickly the transaction can close, whether the entities have complete due diligence packages on each other, and whether any broker-dealer or investment bankers must be paid in association with the transaction. Where the private operating business is paying for the public shell entity with equity, the current shareholders of the public shell company keep a larger portion of the post-closing equity and therefore own a greater percent of the new combined companies. For example, in a cash transaction, the operating business shareholders may end up owning 90% or more of the combined entities post-closing. Whereas in an equity transaction, the operating business shareholders may end up owning only 60 or 70% of the combined entities post-closing. No matter what, the transaction, in order to qualify, the transaction must result in the private company shareholders owning 50% or more of the combined entities post-closing. The percentage of ownership maintained by the public company shareholders will depend on the perceived value of the private operating company that is completing the reverse merger transaction, and an expectation that the value of the share ownership will increase in the future. Accordingly, in an equity transaction, the parties in the reverse merger will negotiate the value of the private operating business. In an equity transaction, the control shareholders of the public company will have to decide whether to accept, say, $400,000 today or maintain a stock ownership in the company, in the combined companies, that they hope will be worth much more than that in the future. Obviously, the valuation is a very important factor in determining the cost of acquiring a public company and going public via reverse merger. In the next segment of this lawcast, I will discuss factors in determining valuation. And in the final segment in this series, I will go through the advantages and disadvantages of completing a reverse merger. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance. Should you have any questions about today's topic, please visit securitieslawblog.com or contact me directly. Inquiries of a technical nature are always encouraged.